This isn't me.
Yeah.
Sergeant Edmonds? Oh, hey.
Yes.
Hey, I was okay with the first guy there. I just had the paperwork up, but we can go ahead and do, is this Mr. Mosley?
Yes, ma'am.
Okay, we can go ahead and do his.
Yes,
Okay.
ma'am.
Just kidding, you can't have it yet.
All right, we're on the record by Zoom in calls number 241-1054-20 State versus Jabori, Jabori Mosley, Mosley. Charged by an indictment of the offense possession of controlled substance, state jail felony. He's present by Zoom along with his attorney, Mr. Clifton Roberson, Mr. D. Chambliss, represent the state. Of course, probation officer Marcelo is also present by Zoom. Mr. Roberson, you want to waive the reading and presentation of the indictment and all the other formalities?
Judge Wade, the former reading of the indictment, his name's correctly set forth in the indictment, knows the range of punishment, what he's charged with, gonna change the plea from not guilty to guilty. This is a mandatory probation case, but he's gonna waive probation and a plea to state jail time, Your Honor.
Raise your right hand, Mr. Mosley, where I can swear you in. Do you solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, and nothing but the truth, and all these documents signed and or signed and sworn to by you were all done by you freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor, it's true.
All right, Mr. Mosley, you understand all the allegations and the charge in this indictment for possession of a controlled substance, meth, in an amount of less than a gram?
Yes, sir.
You understand full range of sentencing is not less than not less than 180 days, no more than 2 years in a state jail cell. The fine may be assessed up to $10,000. You understand that?
Yes, sir.
I'm sorry, you can put your hand down, Mr. Mosley. You're sworn in now. You understand what Mr. Roberson just told the court here on the record, that this is a mandatory probation case. In other words, you would have a right, if you wish to do so, to receive probation in the case. However, of course, the probation would be, in all likelihood, a longer period of time than 7 months. But Mr. Roberson has advised the court that you have made a voluntary decision to waive, to give up your right to probation and to accept this plea agreement, plea bargain, which the court's going to follow, where if you plead guilty, the court's going to assess the sentence at 7 months in the state jail facility with credit for time served.
Yes, sir.
Is that all correct?
Yes, sir.
All right, there is up there right now on the front of the screen, your plea agreement, which I just said is going to be 7 months in a state jail facility with credit for time served. Now, Mr. Roberson, as usual, has figured it, the time credit he's written on this sheet. Now, the jail will go by how they figure it, but normally Mr. Roberson has it right. Your time credit shows to be from May the 9th, 2020 to July the 3rd, 2020, and then from July the 8th, 2020 to the present. So that's your plea agreement. Is that correct?
Yes, Your Honor.
Also, you'd be ordered to pay $180 restitution to the Department of Public Safety lab for the analysis of the controlled substance. Now, looking down that document on down further on the agreed punishment recommendation, these plea papers are all signed by Zach Gilmore, an assistant district attorney. They're signed by Mr. Roberson, and up above where Mr. Roberson is signed, on the line above where it says defendant, there is a signature Is that your signature signed Jabari Mosley?
Yes, sir. Yes, Your Honor.
All right, now that signatures on all these plea documents, Mr. Mosley. Some of the documents show you signed the document, and now under your oath, you have signed and sworn to the documents that indicate they're sworn to. Do you understand all that?
Yes, Your Honor.
All right, so I'm gonna identify the plea papers now. I've already been over the plea agreement. There's an acknowledgement of admonishments with 5 admonishments. Your signature and Mr. Roberson's are right below the 5th one. You do understand you're waiving, giving up your right to a trial by jury and telling the court you just wish to proceed on your plea of guilty to the indictment without a jury. Is that correct?
Yes, sir, Your Honor.
Then you signed and sworn to a waiver of confrontation with witnesses. You signed and sworn to a stipulation of evidence, states 2. Do you understand that's a written judicial confession signed and sworn to by you, an admission under oath to all the allegations and the charge in the indictment?
Yes, sir, Your Honor.
Did you sign and swear to the stipulation of evidence, Mr. Mosley, of your own free will, sign and swear to it voluntarily?
Yes, sir, Your Honor.
All right, court approves stage 2, that there's an agreement to stipulate testimony form for a waiver of appeal, request for waiver of the pre-sentence, which is approved, trial court certification of your rights to appeal, and a certification from you and Mr. Roberson back to the court on your understanding of your rights to appeal. I'm going to go through and ask you some questions now, Mr. Mosley. These are all standard questions. Do you have any questions for me before I ask you these questions?
Just my specific release date.
I don't have it and I won't have it, and that's all figured by the jail.
Yes, sir, Your Honor.
In other words, what I know is Mr. Chambliss is recommending your sentence at 7 months with credit for time served.
Yes, sir, Your Honor.
Mr. Ropes has written his figuring on there as usual, but the jail determines the credit you have in the jail. Do you understand that?
Yes, sir, Your Honor.
All right. Other than that, I've just got a few questions to go through here with you, and we'll
Yes, sir.
get this done. You do read, write, and understand English, obviously. Is that correct?
Yes, sir, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything about the facts of your case with Mr. Robeson, your attorney?
Yes, sir.
Is he competent, Mr. Robeson?
He is, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
Court notes State's counsel signed, gives consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed or signed and sworn to by the defendant, and all the plea documents signed or signed and sworn to by the defendant. All right, Mr. Mosley, in this cause number 241-1054-20, what is your plea today to the indictment charging you with possession of a controlled substance, a state jail felony?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because you have any type delusion in your mind?
No, sir.
Are you entering your plea of guilty to the indictment because you have any unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your plea of guilty to the indictment. Mr. Mosley, what do you have, Mr. Chambliss?
Your Honor, we would offer states 1, the plea packet, states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance.
No objection, Your Honor.
With no objection, court admits into evidence states 1, all the plea papers, states 2, the signed and sworn to stipulation of evidence, states 3, discovery compliance. Court finding the defendant's waiver of his rights, execution of all the other documents are all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty, the court does find the defendant guilty of the offense of possession of a controlled substance, a state jail felony, as alleged in the indictment. Moving to sentencing, Mr. Chairman.
Your Honor, we would offer States 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
States 4 is admitted into evidence without objection. The court in the case then having received and accepted the defendant's plea of guilty, the court having found the defendant guilty of the offense alleged in the indictment, the court does follow the plea agreement, the recommendation of the state, and sets the sentence in the case at 7 months in a state jail facility with credit for time served, restitution or to DPS for the lab fee in the amount of $180. And legal reason for the sentencing, Mr. Robertson.
No legal reason, Your Honor.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense alleged against him by the state in its indictment. Follows the plea agreement, the recommendation of the state, sets the sentence at 7 months in a state jail facility with credit for time served. No fines assessed, restitution or to DPS in the amount of $180 for the lab fee. Waiver of appeal, giving up the defendant's right to appeal, signed by the defendant and his attorney. Waiver for motion for new trials proved, both accepted by the court. Court, for having formally pronounced sentence, court does order Mr. Moses will be continued to custody of the sheriff until such time as he can be transported to a state jail facility to serve the sentence assessed by the court following the plea agreement. The sentence being assessed at 7 months in the state jail facility with credit for time served. Mr. Mosley, only one other question. Are you satisfied with the legal representation in this case provided by your court-appointed attorney, Mr. Roberson?
Yes, sir, Your Honor.
All right, anything else, Mr. Chambers?
No, Your Honor.
Anything else, Mr. Roberson?
Just a waiver of appeal, Your Honor. I think you need to go.
Yeah, I've got a waiver of appeal. I may have been, you may have missed it. I believe I've said, if I didn't, the court accepts and approves the defendant's waiver of appeal, giving up his right to appeal, signed by the defendant, Mr. Mosley, and signed by his defense counsel, Mr. Roberson.
Yes, Your Honor.
If there's nothing else, we'll be in recess. Now, defendants continued in custody till he can be transported to a state jail facility to serve the 7-month sentence assessed by the court with credit for time served. We're in recess.
Mr. Mosley, would you let the sergeant know I need Jason Smith?
Jason Smith. Mr. Mosley will let him know.
She can hear us.
Yeah. All right, we're on the record in cause number 2410394-20, State versus Jason Smith, who is present before the court by Zoom with his court-appointed attorney, Mr. Clifton Robertson. Mr. Chambliss is present for the state, understanding from my coordinator that this is, all right. Let me get the indictment out here just a minute. All right, the indictment, 2410394-20, filed March the 5th, 2020. Appears to be the indictment charges a first-degree felony for manufacture, delivery of a controlled substance. Alleges the defendant Jason Smith on or about the 25th day of September 2019 in Smith County in the state of Texas. Jason Smith did then and there knowingly possess with intent to deliver a controlled substance, namely methamphetamine, in an amount of 4 grams or more, but less than 200 grams, including adulterants or dilutants. So the indictment, as alleges a first-degree felony offense. What are the announcements on this one, Mr. Chambliss? What's says the state?
Your Honor, this was honestly, I think the defendant holds the keys on this one. Mr. Roberson and I had worked out what we thought was an agreement, and he let me know this morning that he wasn't sure if his client was going to take it. So I guess if it's not accepted today, or at least put on the record that he's accepting the offer, then I'm going to withdraw the plea offer and we'll set it for trial, and we'll go to trial on a first-degree felony.
All right, let me get Mr. Smith sworn in just for that purpose. Just raise your right hand, Mr. Smith. You solemnly swear the testimony you'll give here this morning will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right.
Judge, and I can inform the court.
Go ahead, Mr. Rose.
I can inform the court that I had conversations with my client. As the court read the indictment, it was a first-degree felony, possession with intent, which was more than 4 grams but less than 200 grams. The offer was 15 years. I kept negotiating with the prosecuting attorney, Mr. Chambliss, and we came to a decision, dropped intent, which will make it a second-degree felony, 2 to 20, and he came up with 12 years. I informed my client about the 12-year sentence on a second degree instead of not a first degree. And my client was trying to see if I can get less than 12 years. I told him there's no way I can get less than 12 years. That was a recommendation. And we're before the court to see if he wants to accept it or reject it, Your Honor.
All right, all that, of course, is correct, Mr. Chambliss.
That's correct, Your Honor, but I do want to make it clear that if the defendant does not accept the agreement, the offer to drop the intent to deliver language, I'm not dropping the intent to deliver unless he pleads today. So
no, the court understands that.
Yeah, so it will remain a first degree if he doesn't accept the offer today, and if he does, then I don't have a problem dropping the intent to deliver and him putting on the record that he'll take 12 years.
All right, you're under oath, Mr. Smith. We're here by Zoom, so the court needs to determine apparently whether or not you are going to accept the offer of the state, which is to accept the plea of guilty to a lesser included offense of a second degree felony carrying a sentencing range of 2 to 20. And the state's recommendation at 15 years, that appears to be, which would be assessed with credit for time served. That appears to be the offer. As the court understands it, in the final analysis, it's up to you, as it is in the end, up to every defendant. What the court needs to determine today is whether or not you are going to accept that offer, and then plea papers would be drawn up, which would reduce the first degree felony offense carrying a maximum of 99 years for life down to a second degree felony, 2 to 20. And then there would be plea papers set out for 15 years. On the second degree, that 15 years would be assessed with credit for time served. The court will follow the plea agreement if that is the plea agreement and it goes through. So bottom line here is this morning, if you accept the plea agreement, plea papers will be drawn up. We'll be back on Zoom and we'll do the plea for 15 years with credit for time served. If you do not, if you reject the plea, which is certainly your right, the court will set the case for a jury trial Monday, October the 5th at 10 o'clock, and then the court would not accept and Mr. Chambliss would not make any further plea agreements. So what do you want to do, Mr. Smith? Do you want to accept?
I thought the offer was 12,
It is 12, Your Honor.
I'm
Not
sorry,
15.
what did I say?
15.
It's 12. That's my mistake,
Well,
Mr.
I just wanted, I mean, I didn't, there was no intent to deliver, but it was,
They're dropping it. Under the plea agreement, that's how that goes from a first to a
all
second.
right. Well,
Is
I mean, I just felt like 12 years was a little much. I mean, I would do 8. I would sign for 8 right now. And I mean, that's,
It has to be agreed on by both the parties, Mr. Smith. And
I mean, because there was no manufacturing delivery. I mean,
here's the deal, Mr. Smith. Hold on a minute now. Don't start going off into
okay, yes, sir.
don't start going off into what you say the facts are or not, because you're on the record here and what you're saying is being transcribed. That may not be a problem for you, but all I need to find out this morning, and I misstated that the offer is 12. Is that correct?
That's correct, Your Honor.
Okay, I misstated that. The offer is 12 years. So if you want to accept the 12-year, that would be with credit for time served. Today, plea papers would be drawn up and you'll be back on Zoom, and you'd enter a plea of guilty to a second-degree felony possession. And then the state would recommend 12 years, which I would follow, and I would assess the sentence at 12 years in TDC with credit for time served. So that's where we are. I mean, it appears to the court, Mr. Chambliss can tell me if this is not correct. It appears to the court that Mr. Chambliss is not going to make an offer less than the one that's on the table before you today. Is that correct, Mr. Chambliss?
That's correct, Your Honor.
So do you want to go forward with the plea and have the plea papers drawn up and we'll bring you back on Zoom?
Will I get credited for the time that TDC's credited me?
Judge, I informed my client that he will get that credit because they did have a hold on him, Judge. And on the paperwork, I will put the credit from the time that Smith County placed a hold on him.
Okay, that would
For
answer
what?
that. Just a second. Hold on a minute, Mr. Smith. You agree with that, Mr. Chambliss?
Your Honor, and I think partially what he's asking is he got arrested, he bonded out. There was a rearrest. During that time period, he's also been sentenced to, I think, a 2-year sentence out of another county. And I don't know that if he's asking this, but I don't have any problem with the court running this sentence concurrent with whatever he got if he's not finished with his 2 years that he got out of, I believe, is Ellis County. Is that correct?
Yes.
Yeah. If the court runs it concurrent with what he's getting out of Ellis County, he was benched back here. I think Mr. Roberson's correct. There was a hold placed on him while he was in jail in Ellis County. My understanding is that he would get credit for that time as well.
Good
That's
enough.
my understanding, Your Honor.
Good enough. Appears you'll get credit for that time, Mr. Smith, based on what both the lawyers are saying.
Okay, and there's no way we could reset it so I could talk to my attorney?
Sure. We can recess, but I have other cases. I don't know how much, I mean, sure, we can recess. You'll have every opportunity to talk to your lawyer, Mr. Robertson, you wish to talk to.
But
But I may have other cases I have to go on to. I'm not sure exactly how long. It's up to you, Mr. Robertson. Mr. Robertson,
And Judge, we can do this. I can send out the plea papers for the 12 years with his credit. We can do it next Tuesday. I'm set September the 2nd at 10 o'clock on several cases. If he takes a plea, we do it on that date. If not, then it's set for October 15th for trial on the
All
first
right.
degree felony.
the court's going to follow that suggestion. I'm going to set it. My court coordinator already had a date to do a plea if it does go through on that date. So the court is setting it for a plea as outlined between the state defense and the defendant at this point. If he still hadn't made up his mind for sure. but the court is setting it for a plea on September the 2nd at 2:00. Then on September the 2nd at 2:00, it'll either be a plea pursuant to following the agreement outlined by Mr. Chamness and Mr. Robeson, or it'll be set over for a jury trial on Monday, October the 5th, and the court will not accept a plea. So that appears to be where we are. That'll give Mr. Smith plenty of time to talk to Mr. Roberson. So we'll just reset this hearing over to September 2nd at 2:00.
Yes, sir.
Yes, Your Honor.
All right, Mr. Chamness,
Works for me, Your Honor.
we're reset.
Thank you.
Mr. Smith,
Y'all have a
you
good
let
day.
him know I need Jonathan Morris, please. Okay.
We need,
Thanks.
we need Jonathan Morris, Mr. Smith.
Yes, sir. Y'all have a good day.
Yeah.
Same to you.
You can take that mask off.
All right. We're on Zoom, by Zoom, State versus Jonathan Morris, Morris, in cause numbers 241-1051-20, calls 241-1052-20, calls 241-1053-20. Jonathan Morris is before the court by Zoom with his court-appointed counsel, Mr. Roberson, by Zoom, and State's Attorney, Mr. Chamness, by Zoom. Doesn't appear to be any plea papers in the file, so apparently this is for announcements this morning. Is that correct, counsel?
That's true, Judge. There's a co-defendant case by the name of Logan Carr. Also, I was discussing this case with the district attorney's office this morning. There's some information they gave me that I need to talk over with my client. If we can have this set on the same date as the co-defendant judge, we should have it disposed of, or it would have to be a trial.
What's the co-defendant's name?
Logan Carr, C-A-R-R.
That name rings a bell for some reason.
Right, he's represented by
had a-
Jason Harris.
I'm sorry, what, Mr. Champ?
We had a setting on Carr about a week ago and we moved his case to September. And so, and this is a co-defendant.
All right, so what, if I understand it, then, Mr. Robeson, you and Mr. Chamness are asking to move these three cases to what date?
Can't do it the same day.
What date?
I don't know if the date the co-defendant is said. I know it's
Hold on.
Logan Carr.
September 16th. I just get
We-
the date from Denise.
At 9:30.
September the 16th at 9:30.
That would be fine, Your Honor.
These three cases are reset for that date, September
16th at 9:30.
16th, September 16th at 9:30, to determine whether or not they're going to be plays. If they're going to be plays, it'll be on that date. If they're not, then the court won't accept a plea after that. It'll just be on the trial docket.
Yes, Your Honor. Thank you. I appreciate it.
Nothing further. We'll be in recess. Defendants continued in custody.
Thank you, Your Honor.
All right, anything else, Mr. Chambers?
No, Your Honor.
All right, Edmonds, we need Mario Lopez, please.
You can take the mask off if you need to.
All right, we're on the record in cause number 241-0580-20, State versus Mario Lopez, is before the court by Zoom with Mr. Clifton Roberson, defense counsel by Zoom, Mr. Chamness representing the state by Zoom, and the court's probation officer, Marcella, by Zoom. All right, Mr. Chamis, what do you got here?
Your Honor, this, we had already dealt with this issue, I think it was last week or maybe the week before last, where instead of doing the motion to adjudicate, he had agreed to take time and safe P. And I think the court will probably remember this is the defendant who we put on the record that he was going to have to stay in jail until January, which is when the probation officer indicated the first bed at safe P was going to be available. And so I had told the court at that point in time, just so that we would have something formal on the record and the defendant would know, that I would file a motion to withdraw and amend his terms and condition. This motion to withdraw includes the language that he's to remain in the Smith County Jail until he can be transported to Safe P. So I had already put on the record we were going to send him to Safe P, but this is the formal motion to adjudicate, to withdraw that, and to amend his terms and conditions of probation.
I do recall that. Is that all correct, Mr. Roberson, just for the record?
And Judge, that is correct, and we want to put everything on the record since it's around January 2020 before he can go to Safe P, Your Honor.
I do. I remember that, and I remember the length of time we were looking at. Just raise your right hand, Mr. Lopez, just so I can swear you in. You solemnly swear the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, Mr. Lopez, what I have in front of me, it's up on the screen. You can see it. It's signed by Mr. Chamness, Assistant Criminal District Attorney. It's actually appears to be a motion also signed by, that's Tyler, that's our probation officer. And I'm going to just go over the motion with you, Mr. Lopez, to be sure you understand it. This order withdraws the state's motion to adjudicate. We had a prior hearing. If the state went forward on its motion to adjudicate and the court found, as I would have told you at the times, that you had violated terms and conditions of your deferred adjudicated probation, the court could grant the motion. The court would go back and find you guilty of the offense charged in the indictment, and then you could receive up to the maximum. However, at that time, there was an agreement, and there still is, where the state would withdraw its motion to adjudicate and amend the terms and conditions of your community supervision. So the order's on the screen and you can see them. You're continued on deferred adjudicated probation under this order, which will be signed by the court. You can see, in fact, where you can actually see how it reads, and that would be that the motion to adjudicate you, which if granted, the court would go back, find you guilty, and you could receive up to the maximum. The motion to adjudicate is in the same as hereby granted. So the motion to adjudicate is granted, and the conditions of community supervision heretofore granted in this cause are in all things continued in full force and effect, with amended conditions as follows. 54, you're assigned to a level 2 intensive supervision for a term of 1 year after release from the Safe P inpatient treatment program. And after your release from the Safe P treatment program, continue on then your probation. You're ordered by the court to report each week as directed by your supervision officer. Then under 55, which you can see, you're ordered to submit. This is why we're back here today. As Mr. Chambliss was explaining, 55, you're ordered to submit to a substance abuse felony punishment facility as ordered by the attached special condition of community supervision. Supervision fees are waived while in custody awaiting Safe P placement and while participating in the Safe P inpatient program. Payment of all other court-ordered fees will begin upon release from the Safe P inpatient program. Then you'll see 57, submit yourself immediately to the Smith County Jail. Obviously, you are already in the Smith County Jail. This is what Mr. Chambliss was talking about. This is really the bottom line of what we're doing today. You are ordered as a condition of your probation to remain in the Smith County Jail until you are transported to the substance abuse felony punishment facility program. So do you understand that, Mr. Lopez?
Yes, sir.
And the reason we've come back, done a formal order, as Mr. Chairman has said, is so that it's all clear on the record that that it's a term of your probation. You're going to remain in the Smith County Jail until you can be transported to the Substance Abuse Felony Punishment Facility Program, because they have to have an opening for the court to get you in and probation officer to get you in. Then 60, attend and successfully complete all aftercare programs for alcohol, drug treatment as directed by your supervision officer. Do you understand that, Mr. Lopez?
Yes, sir.
So bottom line is what this order does, it continues you in the custody of the Smith County Sheriff in jail until such time as you can be transported to a Safe P facility. Then you'll be in the Safe P facility, which is locked down until you successfully complete the program. And then, as I would have told you before, you come back here on probation, report to your probation officer. Do you understand everything taking place here, Mr. Lopez?
Yes, sir.
Anything else, Marcella? I'm sorry, Marcella, can you hear me?
Yes, Your Honor, and it's on condition number 54. It's 2 years ISP, Your Honor.
It does exactly say that.
Yes, Your Honor, and there's a special condition attached to the order.
That is correct. 54 under this order that's up on the screen. 54, Mr. Lopez, you're assigned to a level 2 intensive supervision for a term of 1 year after release from the Safe P inpatient treatment program. And during this term, that 1 year, you're ordered to report personally each week as directed by your supervision officer. Do you understand that?
Yes, sir.
So when you complete the lockdown Safe P substance abuse felony punishment facility, of course, if you do not follow all the rules and regulations of the substance abuse felony punishment facility, that would violate your probation. You would then be shipped from the Safe P facility back to the Smith County Jail, and then there would be a hearing on the state's motion to adjudicate your case. Do you understand that?
Yes, sir.
60, you are ordered again as a condition of your probation. Once you finish the Safe P program, you're ordered to attend and successfully complete all aftercare programs for alcohol, drug treatment as directed by your supervision officer. Do you understand all that?
Yes, sir.
And the court has signed the modification special conditions. This is the 24th day of August, 2020, date on it. All right, anything else, Mr. Chamness?
No, Your Honor.
Anything else, Mr. Robeson?
No, Your Honor.
Do you understand all this, Mr. Lopez?
Yes, sir.
Now just bear in mind, you gotta successfully complete that Safe P program. Once there's an opening and you're transferred down there, you'll be transported by sheriff's deputies, and that's inpatient when we're talking about lockdown. If you bust out of that program, if you don't follow the rules and regulations of that program and you bust out of it, the state can then use that to revoke or adjudicate your probation, and that can result in you receiving a term in the Texas Department of Corrections Institutional Division up to the maximum for the offense, which is aggravated assault with a deadly weapon, which would be a second-degree felony. Do you understand all that?
Yes, sir.
Anything else, Mr. Chambliss?
No, Your Honor.
Anything else, Mr. Robeson?
No, Your Honor.
Anything else, Marcella?
No, Your Honor, nothing further.
We're in recess. Defendant's continued in custody till he can be transported to Safe P program.
I'm waiting on the main jail. Do you want to go ahead and do your out of jail, Clifton?
Yeah, let me go see if he's in the office.
Okay.
Okay.
Oh, they're in the office. I need a recess.
Bruce. Well, we gotta do this, Bruce.
soon as I'm done here, I'm going straight to the hospital. I just had a big, massive bloody poop. Like straight blood came out. Close that door. Yes, sir. No, sir. Yes, sir.
We're on the record in calls number 24106-39-20, State versus Bruce Gaynor, Gaynor, Georgia State Jail, found in possession of controlled substance less than a gram. He's present by Zoom from his attorney, Mr. Clifton Roberson's office. Mr. Chambliss is present by Zoom. Mr. Roberson, you want to waive the reading, formal presentation of the indictment, all the other formalities?
Judge Wade, the former reading of the indictment, his name is correctly set forth in the indictment, knows the range of punishment, gonna change his plea from not guilty to guilty, Your Honor.
All right, Mr. Gaynor, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, nothing but the truth, so help you God?
I do, sir.
All right, Mr. Gaynor. First of all, do you understand all the allegations and the charge in the indictment for possession of a controlled substance?
Yes, sir, I do.
You understand that's a state jail felony, carries a sentencing range of not less than 180 days, no more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. Do you understand that?
I understand, sir.
I've got a set of plea documents here I have to go through and identify for you. First one's up on the screen. It's the agreed punishment recommendation, signed by Ms. Anderson, Assistant Criminal District Attorney, signed by Mr. Roberson. There's a signature on the line above where it says defendant, which is on every plea document. There's a signature, and then printed is Bruce Gaynor. That's obviously your signature, correct, Mr. Gaynor?
Yes, sir.
Your plea agreement, as the document indicates, if you enter a plea of guilty to this state jail felony indictment, state's going to recommend your sentence at 5 years deferred adjudicated probation as one of the 70 or so conditions of your deferred. You'd be ordered to pay $180 restitution to the Department of Public Safety for the lab analysis of the controlled substance, which turned out to be methamphetamine in an amount of 1 gram or more, but less than 4 grams. Is that your plea agreement, Mr. Gaynor?
As I understand it, yes, sir.
Is that it, Mr. Robeson?
That's correct, Your Honor.
Is that it, Mr. Chambliss?
It is, Your Honor.
All right, these are the other plea documents I've got. And you understand, Mr. Gaynor, obviously you signed all these documents. Now you've sworn to the ones that indicate they're sworn to. Did you go over all these documents with Mr. Robeson so he explained the documents to you where you understood what you have signed or signed and sworn to?
Yes, sir.
All right, your plea agreement, 5 deferred, payment of restitution, $180. It'd be about 70 or so terms and conditions of your deferred, which your probation officer will go over with you as soon as you report to probation. Acknowledgement of admonishments, 3rd-degree felony, carries a sentencing range of not less than 2 years to more than 10 years in the Texas Department of Corrections Institutional Division. Fine may be assessed of up to $10,000. Do you understand that?
I understand, Your Honor.
The amount alleged in the indictment for the meth is 1 gram or more, but less than 4 grams. That's a 3rd-degree felony. So we've got the 5 admonishments with your signature and Mr. Roberson. We've got a waiver of trial by jury. You obviously understand you're waiving giving up your right to a trial by jury.
Yes, sir.
You're waiving confrontation with witnesses and agreeing to stipulate testimony. Is that correct?
Yes, sir.
You signed and sworn to now a stipulation of evidence. That stipulation of evidence states too, that's a written judicial confession under oath by you to the allegations and the charge in the indictment. Do you understand that?
Yes, sir.
Did you sign and swear to the stipulation of evidence freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Court approves, states two, the signed and sworn to stipulation of evidence. Got an agreement to stipulate testimony on the plea, got a form waiving the defendant's right of appeal, signed by the defendant, signed by his attorney. Request to waive the pre-sentence, which is approved. And the remaining plea documents we've got are the request for waiver of the pre-sentence, trial court certification of the defendant's rights to appeal, certification from the defendant, Mr. Roberson, on advice the defendant's received on his rights to appeal from his defense counsel. All these plea documents being signed or sworn to, signed and sworn to by you, Mr. Gaynor, and by your attorney. You do understand all the documents, is that correct?
Yes, sir.
You understand if you do plead guilty to the indictment, Mr. Chairman, the state's attorney is going to recommend your sentence at 5 years deferred adjudicated probation. You'd be ordered to report on down to the probation officer. You'd have about 70 or so terms and conditions. If you followed all those terms and conditions over the next 5 years, the state would dismiss the indictment. The other side of the road on deferred adjudicated probation is if you violate any of the terms and conditions of your probation, the probation department will file a violation report with the court. That'll trigger a no bond warrant for your arrest. It'd be a hearing held in this court before a judge, not the jury. If the judge determined you had violated any condition of your deferred, the judge could grant what's called the state's motion to adjudicate. The court would go back, find you guilty of the offense charged in the indictment, and then because you were on deferred, the court could assess your sentence up to 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. Do you understand all that?
Yes, sir.
All right. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcohol in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you ever been in a mental institution or under any type of psychiatric treatment?
Yes, sir.
Did you say yes?
Yes, sir.
All right. Without going into it right now, are you under the care of any psychiatrist or any type other physician?
Not at the moment, sir. No, sir.
All right. Are you taking any type of prescription medication at this time?
I'm on a anti-inflammatory, and I also have been prescribed Tylenol 3
Okay.
with codeine. I am not on Tylenol 3 with codeine at the time. I take it as needed only.
The bottom line on it would be, are you taking any medications you're prescribed pursuant to and in accordance with the prescriptions?
Yes, sir. I am taking them correctly.
All right. Have you been over the facts of this case and everything you're doing on Zoom today in the plea with your attorney, Mr. Roberson?
I believe so.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
Court notes state's counsel signed his assent approved the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant, signed by his attorney. All right, you understand the full range of sentencing, all your plea papers, all the allegations in the indictment for possession of controlled substance, a state jail felony, and your plea agreement. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, Your Honor.
All right, in cause number 2410639-20, what is your plea today to the indictment charging you with possession of controlled substance, a third-degree felony as alleged in the indictment?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you pleading guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
I'm sorry. I don't understand that question.
It's sort of a two-part question. Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind?
No, sir.
Are you entering your plea of guilty to the indictment today because you have any type unrealistic hope of pardon, parole, or leniency?
No, sir.
Court does receive and accept your plea of guilty to the indictment. What do you have, Mr. Chambliss?
Your Honor, at this time, we would offer states 1, the plea packet, states 2, the sign of sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection, Your Honor.
With no objection, states exhibits 1, 2, and 3 are admitted into evidence. The court having admitted into evidence states exhibits 1, 2, and 3. Court finds the defendant's waiver of his rights, execution of all the other plea documents in the case were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in the case was entered by the defendant to the indictment in the case freely, intelligently, knowingly, and voluntarily. However, the court does withhold a finding of guilt as to the defendant, and we will proceed to sentencing. Mr. Chambers.
Yeah, we would offer states 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
Stage 4, all the offense investigative reports, lab report, all admitted into evidence with no objection. The court's approved the waiver of the pre-sentence. Court in the case then, based upon the defendant's plea of guilty to the offense alleged against him by the state in its indictment and the evidence presented and admitted into the record by the court does find that evidence in the record on the defendant's plea of guilty to the indictment is fully sufficient to support the defendant's plea of guilty to the offense of possession of controlled substance, third-degree felony is alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant follows the plea agreement, the recommendation of the state sets the sentence in the case at 5 years deferred, adjudicated probation, no fines assessed, court costs already paid, restitution to our Department of Public Safety lab in the amount of $180. Any legal reason for formal sentencing, Mr.
No legal reason, Your Honor.
In finding none, the court does formally pronounce the sentence. The court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment, third-degree felony, possession of controlled substance. However, the court does withhold a finding of guilt to the defendant, follows the plea agreement, formally pronounces sentence at 5 years, deferred, adjudicated probation, withholding finding of guilt. Court has received from you, in this case, signed by you and signed by Mr. Roberson, a waiver of giving up your right to appeal and a waiver giving up your right to file a motion for new trial. Do you understand those two documents, Mr.
Yes,
Gaines?
sir.
Court receives and accepts the waiver of appeal, receives and accepts the waiver of right to file a motion for new trial. Court, following the plea agreement in the case, now has assessed your sentence, and the judgments will be signed today. Will assess your sentence at 5 years deferred adjudicated probation under all the terms and conditions of your deferred adjudicated probation, about 70 of them, which will be explained to you one by one by your supervising probation officer. Need to be sure you do understand this also. You can be on the deferred for up to a term of 5 years. If any time during that time, your probation officer determines, let's just say you fail a drug test with meth, that's your best likelihood of going to the pen. Let's just say you fail a drug test. They'll be sending you to some outpatient courses for treatment, rehabilitation, because meth is so addictive. But if you did fail a drug test or violate any other condition of your deferred adjudicated probation, the state would immediately file with the court a motion to adjudicate your case, alleging violations of your deferred adjudicated probation. That would cause a no bond warrant to go out for your arrest. And then a hearing would be scheduled in this court. Once you were apprehended or turned yourself in, there'd be a hearing before the judge of the court, not a jury. If the judge determined from the state's evidence you had in fact violated any of your conditions of your deferred, as I've used the example, failing a drug test, the judge then can grant the state's motion to adjudicate, finding the allegations alleged proven. And then once that's done, if the court adjudicates your case, and then that means that's a technical word, adjudicate. What it means is the judge goes back, finds you guilty of the offense of possession of a controlled substance, third-degree felony, and then because you were on deferred and violated a condition, the judge could then send you up to the maximum, 10 years in the Texas Department of Corrections Institutional Division, fine of up to $10,000. You understand that?
Yes, sir.
Of course, the other side of the road is, sure you already know from Mr. Roberson, if you serve out your terms and conditions for the period you're on for, which can be up to 5 years, you do not violate any terms and conditions of your deferred adjudicated probation, like passing all of your drug tests, random, unannounced. Then at the end of that term, the state will dismiss the indictment against you. And because you successfully completed the deferred adjudicated probation, you will not have a final conviction on your record for this felony. Do you understand all that?
Yes, sir.
For now, your first term and condition of your deferred adjudicated probation is obviously to report directly to your supervising probation officer at the probation office. Of course, this is different from an individual, obviously, who's in jail getting deferred. Since the court is assessing your sentence at 5 years deferred, of course, your first term and condition of your deferred is to report directly to the probation department. Is that correct, Marcella? Is he to report today?
Yes, Your Honor, he's to come over to the probation department, as soon as he finishes up with court.
All right, so I needed to ask that question, Mr. Gaynor, because now one of the terms and conditions, it's actually in your terms and conditions, is when you leave Mr. Roberson's office here in a few minutes, you're ordered to report as a term and condition of your probation directly to the Smith County Probation Office. Do you know where that is?
Yes, sir, I do, but I do have one question on that.
Sure.
Right before I came onto the screen, I had a massive bloody poop, and I'm literally just had blood pouring out my butt. I was gonna go to the hospital right away. I tried to get Mr. Robertson to stop this, reschedule or something. Is there any way I can go to the hospital first?
That's exactly where you need to go.
Okay.
As soon as we complete, my probation officer, Marcella's on the screen. You can see her. She's hearing all this. Go directly to the hospital.
Yes,
And
I'll
then-
bring a note from them right away.
Yes,
As soon as I
correct.
get home.
Well, it depends on when you get out.
Right.
But go to the emergency room directly
Absolutely, sir.
to the emergency room. When
It's
you're
already
released, from the emergency room, or when you're released from the hospital, your probation term, and Marcella's listening to all this, will read that you're to report directly then to the probation department. Does that answer that question?
Yes, sir. I just wanted to make sure with you. I want to let you know that's where I was
Yes.
trying to get to before this.
Absolutely. I'm glad you brought that up. You need to go straight to the emergency room.
Yes, sir. I'll be heading straight there.
When you leave Mr. Roberson's office. Anything else, Marcella?
Nothing further, Your Honor.
Anything else, Mr. Chairman?
No, Your Honor.
Anything else, Mr. Robeson?
No, Your Honor.
We are in recess.
Thank you,
Good
Your
luck.
Honor.
Good luck, Mr. Gaynor.
I think I
Thank
got
you.
one more here, Your Honor. Okay, on to the hospital. Sure, good. Make sure you go.
Thank you. Have a great day.
Mhm.
I won't be able to remember somebody now.
But wait, let them do their.
Not gonna jump the gun. All right, we're on the record by Zoom. Calls number 2410943-20, State versus John Sparks. He is present before the court from the jail where he's in custody on an indictment charging the offense of murder, obviously a first-degree felony, as alleged in the indictment. He is present by Zoom with his attorney, Mr. Clifton Roberson, who is present by Zoom. State's counsel, Mr. Chamness, present by Zoom. All right, what's the state's announcement, Mr. Chambliss?
Your Honor, we had made an offer to Mr. Roberson. He obviously, there was a voluminous amount of discovery in the case based on the fact that it was a murder case. He had an opportunity to go and talk with his client, go through all the discovery, and just, I believe it was on Friday, and Mr. Roberson can correct me if I'm wrong, called me with an offer that his client was willing to plead guilty in exchange for a recommendation of a certain number. That number is very close to the range that we had offered in the case, but obviously I need to get the victim's family into the office to discuss that with them before we enter into any kind of plea agreement on the case. And so I think both me and Mr. Roberson are just asking for a couple of weeks to reset this, and it'll either be a plea or it won't.
Mr. Roberson, I'm sorry, Mr. Chambliss. Mr. Roberson?
Judge, that is correct. I spoke with my client and we're in agreement. And I think the prosecuting attorney's got to talk with the victim and his supervisor. And a couple of weeks would be fine with us. The paperwork is before the district attorney's office, Your Honor.
All right, based on the announcements by Mr. Chambliss and Mr. Roberson, the defendant's attorney, the defendant being present by Zoom, the court is going to extend the plea deadline under these circumstances to Wednesday, September the 2nd at 1:30. On Wednesday, September the 2nd at 1:30, we'll be back on Zoom with the defendant from the jail and state defense counsel present by Zoom. At that time, for the court to determine whether or not there has been a plea agreement reached. If there has been, the court will follow the state's recommendation and conduct the plea hearing on Wednesday, September 2nd at 1:30. If there's not a plea agreement in place, no agreement has been reached, then that will be the end of the plea. That is the plea deadline, Wednesday, September 2nd at 1:30. So if there is no plea agreement in place, there's no plea pursuant to the plea agreement on Wednesday, September 2nd at 1:30, the case being a murder indictment will go on the first available trial docket, which the court will set it. It'll be on the first available trial docket available to the court, which right now would be some week in October as it stands right now. Is that agreeable with the state, Mr. Chambliss?
Yes, Your Honor. And if by some chance we have an issue and I can let the court know about getting the victim's family in before the 2nd, I'll let the court know that's going to, we'll probably be asking for an extension, but they're local, so I don't anticipate that's going to be a problem. I just want to let the court know that if I know beforehand that they're not going to be able to come in for whatever reason, I will let the court know.
Just let Denise know, and naturally under those circumstances, the court will extend a plea deadline certainly, so you'll have the opportunity that you need to consult with and explain everything to the victim's family. So if there is not anything, you have anything else, Mr. Roberson?
I know, Judge, I was Zoom with my client on Wednesday and let him know what's going on, Your Honor.
All right, then we're going to be in recess on the case today. The plea deadline as it stands right now is extended to Wednesday, September the 2nd at 1:30. We will be back on Zoom with the defendant present at that date and time, unless Mr. Chambliss advises Denise that he needs additional time to get with the victim's family. If that's the circumstance, we'll work out a new hearing date before the court, or if it ends up not being a plea, nothing can be worked out, then at that next hearing, the court will be able to give you the trial docket setting for when the case is set for trial by a jury. Anything else, Mr. Chambliss?
No, Your Honor.
Anything else, Mr. Roberson?
No, Your Honor.
All right. Mr. John Sparks Jr. is continued in the custody of the sheriff under the present bond on the indictment charging the offense, first-degree felony offense of murder. We're in recess until our next hearing.
That's it for me, Denise. I'm gone.
All right, Clifton, thanks.
You're welcome.
Be sure that previous client got to the hospital, Cliff.
Judge, I made sure he went to the hospital. I just wanted to put it on record with you where